Mm-hmm.
Okay. We should get there.
Don't look like that, man.
All right, good evening. I'm going to call this meeting to order. This is the Code Enforcement Special Magistrate hearing of August 23rd, 2023. First order of business is the roll call. So can I have the Code Enforcement officers please introduce themselves?
Mark Gibson, Code Compliance Supervisor.
Danny Robb, Code Compliance Manager.
Renee Kearney, Hearing Clerk.
Volusia, Administrative Assistant.
Marion Laracy, Code Compliance Supervisor.
Nicholas Lopez, Code Compliance Officer.
Todd B, Code Compliance Officer.
Janice Velasic, Code Compliance Officer. Lindsay Longstreet, Code Compliance Officer.
Tyler Russo, Code Compliance Officer.
Sam Schaller, Assistant Fire Marshal.
All right. If you could please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is my statement and opening remarks about how the hearing will proceed tonight. And I'm going to read this so I don't forget anything. Good evening. My name is Kristen Ike. I'm the Code Enforcement Special Magistrate for the City of Deltona. And this is, again, the August 23rd, 2023 meeting. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code enforcement officers here tonight and any witnesses each of you call will be able to present evidence to me regarding each case and the violations of the Deltona City Code that are being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement cases to determine if a violation of the City Code exists and what fine will be imposed, if any. If you are here for a Massey case, which you might see next to your case number on the agenda, that means that I will be determining solely whether you have come into compliance in a timely manner in accordance with the previous order the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed. Any decision I make this evening will be put into a written format in the form of an order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by sending a written notice of appeal to the circuit court within 30 days of the execution of my order pursuant to Florida Statutes Section 162.11. The procedure of the hearings today will be governed by Chapter 162 Florida statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify, tell me what you think I need to know about your case, present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number, and the city will proceed first. The city has the burden of proving that the code violation exists, then you will be allowed to respond. For each case, I intend to admit the case file, and you should have received a copy of your case file when you checked in this evening. If you did not, please let me know when I call your case. I will take the cases in the order that you signed in, first come, first served. I do have a couple of cases that have been withdrawn. and I'll just announce them for the record. One is DEL 23-241. That's for 1369 Bailey Avenue. Case 23-243, which is 1055 Lyric Drive. And then two that are continued, 23-239, 772 East Normandy Boulevard, and 23-238, 887 Deltona Boulevard. So if you're here for any of those cases, you do not need to stay. Okay, I will go ahead and swear in everyone who attends to testify today as a group, which includes the code enforcement officers. So if you intend to speak to me tonight, please stand and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do. I do. Thank you. All right, I have no ex parte communications to disclose, so we can go ahead and begin with the cases. All right, this is 23-246, 1886 Elk Cam Boulevard.
Good afternoon, Your Honor.
Good afternoon.
My name is Nicholas Lopez. I'm employed by the City of Deltona as a code compliance officer. This will be case number DL-23246. The City of Deltona versus Gregory Kleckner. The property address is 1886 Elkham Boulevard, Deltona, Florida 32725. The parcel ID number is 813-015-180-190. This is a violation of City of Deltona Ordinance, Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 504.1, which states that all plumbing fixtures shall be properly installed and maintained in working order and shall be kept free from obstructions, leaks, and defects, and be capable of performing the function for which such plumbing fixtures are designed. Corrective action for said violation is to repair or replace damaged plumbing. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was a reactive case. On July 3rd, 2023, plumbing issues were observed on the property after the tenant, Kimberly Neves, allowed code compliance to conduct an inspection on the residence. A voicemail was then left with Gregory Kleckner, who received notification of the existing code violation, along with emails. As of today, August 23rd, 2023, the property is still in violation with plumbing issues still being present. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance, excuse me.
Okay, can you explain a little bit what I'm seeing in the pictures that you're showing?
So initially, the complaint came out for the sink and the dishwasher in the home having issues with leaking, and the landlord or the property owner, he ended up fixing the dishwasher, but the sink is still leaking as of today. There's been instances where I've walked into the residence and I've seen the resident, Ms. Nieves, having cardboard on the floor to help, mitigate the leak or to help prevent it, towels, shirts, things of that nature. And as of today, we can still see that there is a visible leak underneath the sink. The actual structure of the sink itself, There's photos, Marion, if you wouldn't mind. You can see where the water has risen to the point where it's starting to decay a certain point of the outside structure.
Okay, this is photo 16. This is the outside of the house?
This is the outside of where the sink is placed. It's on its own island.
Oh, and so, okay. This is indoors, but it's like the outside of the island?
Yes, ma'am.
Okay.
And at certain points, I have felt it, and it's been wet to the touch. Today, it hasn't, but it was rotted. You know, it has rotted, and it has been wet to the touch at certain points, to my recollection.
Okay. And they were given a date to comply by what date?
Stand by, ma'am.
On the notice of violation.
August 3rd, 2023.
Okay. All right, and I see a number of text messages in the file.
Yes, ma'am.
What is this?
The text messages that were provided in Exhibit B were provided by the tenant, Kimberly Nieves. She is here to testify, and they were messages that are relevant to her asking the property owner for the violation to be repaired, and for one reason or the other, we haven't been able to get this to come into compliance. There's also emails that have been provided in Exhibit B where I've notified the property owner, letting them know that there is a violation, what it's for, etc.
Okay, give me a moment to review some of this material in the file.
Yes, ma'am.
Okay, and there's emails as well. These are, you say, the emails where you were emailing with the landlord?
Yes, ma'am. The landlord or the attorney, I believe.
Okay, are you calling the tenant as a witness?
Yes, ma'am.
Okay, can you have her come forward?
Yes, ma'am.
Hi, good evening. Can you state your name and address for the record?
All right, Kimberly Nieves, 1886 El Camp Boulevard.
Okay. What would you like to tell me about the case?
Basically, I've been there for going on like a year and change, and since I've moved in, there's always been a plumbing issue. Roof issue is a lot of issues with, water based, but the island that he has in that home is basically, like the newer islands where you cook and then the sink. So in the beginning, we had an issue where he had to take out tiles, and the same plumber that he brought out to me now is his friend, and he told him the same exact thing, that they cannot fix that plumbing unless they get a Roto-Rooter company to come put like a magnifying, so they could find the leak, because the leak is coming from all the way underneath the grounds. So I explained that to him. I tried to call him. I tried to for months now, and he just sends friends. And I never refuse the person, but I always ask. I have children in that home, and my grandmother that, I take care of. I'm entitled to ask, hey, do you have a license? Are you a licensed plumber? And he said that I was trying to refuse the person to come in. Never, I've never done that. They came in, I have pictures, I have a camera in my home. You know what I mean? So all I asked for him was to please fix it. There was 2 months went by, I couldn't cook. I had to wash dishes in the bathroom, like in my tub, because there was no, it's a lining. Like I think they try to build something that just it's not functionable, So I tried to explain that to him. He was like, I'm gonna send somebody out. I'm a MA, and I go to school, and I have my own business here in Deltona as well. I have a boutique here. I'm all over the place with my children, everything, So every time he tried to send somebody to come out, he's like, you have to be there at 4. I'm like, okay, well, you cannot just call me and tell me like right then and there. I was like, you have to give me a notice, 12-hour, 24-hour notice, something. And I don't mind for anybody to come check this, but he's always giving me a hard time, and he's not gonna fix it. It's still not fixed. I went to the land, and I asked for a 7-day notice to cure for him, and then he tried to hit me with an eviction. So I try to do the right thing because I'm from New York, so I don't know too much the laws here, but I went to the law library, try to find like a way to notify him. Like, if you're not gonna help me, then we're gonna take this to court, like in DeLand. So I went to the courthouse. They told me that I would have to do a process, and let him know. I mailed him paperwork. I came here and did a affidavit, I don't know how to say it, affidavit with you guys. And then I told him, I said, this is disgusting. I have 3 boys in the house. How am I gonna cook? For 2 months, I had to order out, figure out how to maneuver myself, So then he's like, okay, I will help you, I'll help you. Nothing. So when I went to DeLand, he tried to hit me with an eviction because I told him, I'm gonna withhold your rent until you fix this stuff. I emailed him, I text him, I call him. He don't really reply. So then he went and he was like, okay, well then I'm hitting you with an eviction. I said, that's fine. Do what you have to do, and I will do what I have to do. So when I went to court, he lost his case, and he still has plumbing issues, and I decided to move out. I asked the judge if I could just leave, with no eviction, with no, problems. I just want to go. And she granted that. So now, I feel bad for whoever's going to move in there, because they're going to have issues with he wants to move. I already looked at Zillow. He already posted the house while I'm still living there that the lease is about to, somebody can move in. That's fine. That's not my business. But I'm just saying, he hasn't fixed anything. He went and asked somebody to come fix the toilet and the sink. It was flooding like crazy. You know how your toilet's like this? It lifts up. So, whoever lived there before or whatever, they never fixed it. So I told him, I said, it's your toilet. You really need to fix this stuff. And he sent somebody out, a young guy from Kissimmee. His name was David. I made him write in a piece of paper that he came out to see the toilet. He's the one that fixed everything. And the landlord didn't pay him. The kid called me. He's like, hey, your landlord blocked me, or the realtor blocked me. Rick. I don't know him as Greg Clenning, whatever his name is. I know him as Rick, the realtor. But in reality, he's the landlord. So I told the guy, listen, I'm sorry. I don't know what to tell you. I did not hire you. I let you come to my home. The guy was threatening me. I'm going to come take the faucet out and the toilet thing because I didn't get paid. I said, well, you have to figure that out with him. I don't know what else to tell you.
So you're currently still in the home, though? I'm
still in the home, but I'm leaving. I can't live like that. It's been so stressful for me. And I had a mini stroke 2 years ago. I don't need it,
When do you anticipate leaving the premises?
August 31st. The judge gave me from DeLand August 31st by 5. So okay. It was kind of like a little...
So you intend to leave by August 31st?
Yeah.
Okay.
But that home it's not fixed. It's more than that. Lightning hit the window when it's been storming, and he does not have screens. So, and Nick gave him a ticket thing, and he still hasn't fixed that.
Okay.
When the hurricane hit, a tree fell towards the house. There's a big tree. He sent his friend, the same plumber, ABC Repair, to come fix the fence. and they put, I don't even know what they did, and I'm the one that cut the tree down. And
So-
I called City Hall here, and
I want to stay on topic, though, because
sorry.
what I have is, what I'm here to determine is whether or not there's a violation related to
Okay.
the plumbing.
yeah, but it's bad.
Okay. And for the code enforcement officer, what was the recommendation on time to comply?
30 days or $50 per day.
30 days.
Yes, ma'am.
So you would be out of the home by that time.
But, what
That would be,
oh, yeah, I'm leaving.
yeah, that would be September 22nd, would be 30 days. All right. So at that point, there wouldn't be a problem with getting access to the home because you would not be there.
Yeah, no, I'm leaving.
Okay.
It's too hazardous, and I feel like the way I don't think he had a permit to do that island that way, and it's just not safe. So when you're cooking, and you can see it in some of the pictures, the wire goes to the sink. The same wires, everything is all connected. You know, I was gonna call the fire department. I know Lisa, but I didn't know how that works here, you know? So I was like, this is not safe. This is not safe for somebody to be here. So I'm leaving, you know?
Okay. All right. I would like to hear from the respondent.
Good afternoon, Your Honor. Francis Hammond on behalf of the owner, Gregory Kleckner.
I'm sorry, can you repeat it? It's hard to hear.
Yes, Your Honor. Bear with me one moment. This might be better.
I'm really struggling to understand what you're saying.
My apologies. Attorney Francis Hammond on behalf of the respondent, Greg Kleckner.
Okay, that's much better. Thank you. All right,
Thank
so
you.
you're an attorney representing the respondent?
I am, Your Honor.
Okay. All right, please go ahead.
Just very briefly, Your Honor, as Ms. Nieves pointed out in the pending case in Volusia County Court, there is a standing order requiring her to vacate by 5 p.m. on August the 31st. Given the recommendation of 30 days to comply, we fully intend to do so. I would note for the record that plumbers have been out to the property twice, both on June the 29th, at which time they were refused access, and again on August the 8th, at which time remedial action was taken. I'm not disputing the findings presented as of today. Certainly there appears to be work left to be done, but on Officer Lopez's recommendation of 30 days to comply, we would request that that be so ordered, and we intend to bring the property into compliance and have it ready for reinspection within that window.
Okay, so you have no dispute with the 30 days that's being recommended, or the fine?
No, Your Honor.
Okay. All right. I have also an attorney's letter. Is this from you, sir, Francis?
It is, Your Honor.
Okay. Can you tell me what the substance of this is, generally, that it was attempted, the repairs on those dates?
That's it, Your Honor. We also attached and included a dispatch and work log report from ABC Repair, which essentially just helps substantiate the content of my letter.
Okay. All right. Will this be, I don't know if the city can answer this, but I assume it will be the case that they will need to obtain a permit to repair the plumbing.
For repair, it does not require a permit.
Oh, it does not. Okay, thank you. All right, thank you. All right, I'm going to go ahead and find the violation. I'm going to admit the case file as Exhibit A, and I find that notices were properly given in this case. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 22nd, which is 30 days. In the event respondent does not comply by this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. So for the attorney, please just make sure you advise your client to stay in contact with the code inspector and let him know when the repairs are completed.
Absolutely, Your Honor. Thank you.
Thank you.
Thank you.
Next case. What's that? Okay. Thank you. All right, so this is case 23-229, 3389 Vancouver Avenue. Hi, give me just one moment. Okay, here we go.
Okay. Hi, my name is Janice Palasic, and I am employed by the City of Deltona as a Code Compliance Officer. This will be case number DEL 23-229. The City of Deltona versus FKH SFR Propco GLP. The property address is 3389 Vancouver Avenue. The parcel ID number is 813-035-090-070. This is a violation of the City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the fence or to remove the fence. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. This case was opened on April 28, 2023, after addressing other violations on this property. After checking case history, I noted that the fence had been replaced in August 2022, but no permit was pulled for the replacement. I went to the property on March 20th, 2023, and spoke with the tenant, who said she was unable to contact the property owners and advise them of the violation. At this time, I posted a notice of violation onto the property, as well as sent a certified mailing to the property owners listed with the property appraisers. On June 3rd, 2023, I returned to the property and spoke to the tenants. I was able to obtain a phone number for the property owners, which I called and left messages. I then returned to the property on July 13th, 2022, and as of then, I still had not heard from the property management company, and the property was still not in compliance. I posted a notice of hearing onto the property and also sent to the property owners listed with property appraisers. An affidavit of service was also completed. As of today, August 23, 2023, no current permit has been filed with the city, and the fence is still located on the property. The city would like to request 30 days for the property to come into compliance, or a fine of $25 per day to be imposed until such time that the property owner has notified the city of compliance.
Okay, thank you. So how do you know that it's a new fence? You saw that it was...
I checked the case history, and there was a case opened back in December 2021, where the fence was in disrepair and the fence was replaced. Case was closed, but no permit was pulled on the fence.
Okay, so that occurred in 2021?
The fence was in disrepair in 2021. It was fixed in August 2022, and no permit was pulled for the fence.
Okay, all right, so it's been fixed for a year.
Yeah.
All right. Is the property owner present?
Yeah.
You can come forward. You can go to this one here. Hi, can you state your name and address for the record?
Nope, it's not on.
Okay, yes, let him turn that on.
Hi, Jessica Sierra, property manager with First Key Homes.
Okay. What would you like to tell me about the case?
We just learned about this case on Friday when I received the notice. It typically goes to our Georgia corporate office, and then it's mailed over back to us. I did speak to my maintenance department, and they are getting a vendor to provide, to pull permits, and then it should be resolved by Wednesday of next week.
Okay. Okay. So you have no concerns about getting, having a 30-day time period to comply?
No, ma'am.
Okay, thank you. All right, I'm going to find that the notices were properly given in this case. I'm admitting the case file as Exhibit A. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 22nd, which is 30 days. In the event respondent does not comply by this date, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. So please make sure you stay in contact with her.
Yes, thank you.
All right, thanks. What's that? Oh. All right, this is case 23-230, 2250 East Union Circle. Go ahead. You're right. Okay.
My name is Lindsay Longstreet. I'm employed by the City of Deltona as a code compliance officer. This will be case number DEL 23-230. The City of Deltona versus Paula Fernandez and Andre C. Burrito. The property address is 2250 East Union Circle, Deltona, Florida 32725. The parcel ID number is 8130082600120. This is a violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner or authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make an application to the building official and obtain the required permit. The corrective action for said violation is to obtain a permit or remove the structure. The statutory requirements for this notification of this hearing have been met by the notice of hearing and notice of code violation have been sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On March 25th, 2023, I arrived at this property and they were located a shed in the backyard which had no permit. A courtesy notice was left at this time. I later returned on April 1st and briefly spoke with a female resident who was getting in the car to leave, but had advised her husband was not home either, and I had left a courtesy notice at that time. I returned on April 6th, 2023, and checked City Hall records, and no permit was on file. I proceeded with posting a notice of violation to the property with a compliance date of April 16th, 2023. On April 20th, 2023, I still observed no permit on file for the shed. However, I had received a voicemail from the resident explaining he was going to get the shed taken care of. I tried turning his phone call, but unable to leave a message at the time. Over the last several months, contact was attempted about the permit with no response. On May 25th, 2023, the female resident, Paula Fernandez, came into City Hall and spoke to the front staff and advised she would return with a survey of the property and obtain a permit. On August 8th, 2023, I posted the property with a notice of hearing as no permit had been obtained for the shed. As of today, August 23rd, 23, the property still remains in violation with no permit for the shed. The city would like to request 30 days for the property to come into compliance or a fine of $25 per day to be imposed until such time that the property owner has notified the city of compliance.
And you said 30 days?
Yes, ma'am.
Okay. All right, and so I'm looking at a picture of the shed.
Yes, ma'am.
All right, and this is picture one, and your testimony is there's no permit that's been submitted at this point. Okay, one quick question is I think it's probably just in the wrong file. I have a property appraiser's printout for 2849 Huron Drive. That has nothing to do with this case,
No,
right?
no, ma'am, no.
Okay.
I'm not sure how that got stuck in there.
Okay.
We do have a case on that address, so it's a different case.
It just got stuck in the wrong file. Okay, is the property owner present?
Yes, ma'am.
You want to come forward? Go to this.
Hi, my name is Andre Barrero.
Okay.
I live in 2250 East Union Circle.
Okay. All right. Go ahead.
Paula Fernandez.
Okay. What do you want to tell me about the case? And will you be translating?
Yeah.
That is correct, Your Honor. My name is Vanessa Bach, yes.
Okay. All right. Okay. All right. So please ask them what they would like to tell me about the case.
O que vocês gostariam de falar para ela?
Sim, o que a gente gostaria de falar para ela é que a gente comprou a casa, a casinha já estava lá atrás, só fiz uma parte atrás para as galinhas, e que mesmo a proprietária, a real estate que vendemos a casa, me mandou toda a informação da casa aqui, que a casinha aí já estava lá.
Okay. According to them, they bought the property a little over 2 years ago, and according to them, according to them, they bought the property about 2 years ago, and when they bought the property, it came with a shed. The shed was already in the property. According to the consultant that they spoke with at the time, told them that due to the shed being under 120 square feet, was not required to obtain a permit about 2 years ago.
Under how many square feet?
Under 120.
120, okay.
And at the time, a permit was not required. But the reason why he extended the shed, because he had chickens at the time, but he said that little structure besides the shed has been already removed. It's no longer there. It's just a shed.
Okay, so the portion there that I'm seeing in photo one on the right-hand side was added for chickens?
Correct. But that structure has been taken down.
Okay. Can the city respond to that? Is there any exemption for a shed that's under 120 square feet?
Ma'am, this is Danny Ron, the Code Compliance Manager. Anything over 80 square feet does require a building permit.
Over 80?
Yes, ma'am.
Did you want
So
to say
shed this
something?
size, yes, it does require a permit.
Okay.
Okay. All right.
Vocês têm alguma outra coisa que vocês querem falar para ela?
Sim, mas não.
I'm going to, sorry, go ahead.
Que a partir de 100, o nosso tem 130 anos.
Ok.
Sim, mas aqui diz que
Okay, according to them, she received an email from the consultant at the time, giving a little bit more details, information about pardon me, I'm sorry. She received, according to her, she has an email witness for the consultant about the listing of the property and gives a little bit of details about the shed.
Okay.
So I'm not sure if you would be interested in seeing it. This is the only thing that she has.
Would they like me to see? Would they like me to review it?
Mm-hmm.
Okay. Can you bring the? Will they be able to send me or send the city a copy of what's on the email or text, whatever it is?
It's an email, I believe so. I think there might be a way.
Okay.
só quando está fechado ele dá como dedo.
Okay. Okay. She said that it may close out on you. All you have to do is just double tap, and then you'll be able to see it. Thank you.
Officer Longstreet, is this in the easement?
Yes, yes, it was noted that it was in the easement.
Yeah, which we don't allow any accessory structure in the easement. That's what it looks
A
like.
casinha está na linha da propriedade e vocês não podem ter a casinha, infelizmente. Tem que mover a casinha de qualquer maneira.
Okay, so just to be, so the shed is currently located in an easement?
That's
Yes.
correct, right?
Okay.
E que vocês pretendem fazer? Remover a casa, mover para frente, ou o que vocês querem ter uma ideia?
Para mover para frente, para do carro. Tem a fundação, parece que eu vou tirar.
Então você vai
Okay.
ter que tirar.
Here we go.
Okay.
I understand the testimony, but I'd like to see, do you have a copy of the Florida Building Code that you can bring down? Because I'd like to see what it actually says about the exemptions.
About the dimensions?
About the exemptions and the square footage. Do you have it available?
I do not have that available, no.
You
Not at the
don't?
moment, no.
Mr. Schaller is saying something.
Ma'am, if you would like, we could continue this case so that we could provide that information from the building official.
Okay, I think that would be helpful. I mean, I understand the testimony, but I would like to know for myself, see it in actually written, what the exemptions are, since there's conflicting testimony, so I'd like to see that. So I'll go ahead and continue the case. So we'll continue it to the next meeting. Can you ask them if they would have any objection to that, of continuing it to the next meeting?
Ok. Ela está te perguntando, a gente está perguntando se você tem algum problema de continuar o caso, porque ela quer verificar o código da Flórida para construção. E ela quer ter certeza antes de ela te dar, fazer uma decisão. Vocês podem continuar? Vocês estão de acordo ou vocês a continuar o caso porque ela não quer dar nenhuma decisão antes dela fazer toda a investigação?
Ela pode fazer uma investigação, mas essa casa se vai mudar, tem que mover ela para frente, eu tenho que tirar. Se tem que mover, se eu tenho que mover ela por aqui para frente, eu não consigo.
Então, ok.
Então, assim, eu vou cortar ela e vou botar no lixo.
Ok, então você pode continuar o caso até ela verificar ou vocês têm algum problema? Tem alguma... Ela só quer continuar. Mas okay. And how long would you like to extend the case for?
Yeah, the next meeting would be September 27th.
Na próxima vez que você vai ser, setembro, de 22 de setembro. Okay. Yes. Okay.
Ma'am, I would like to also add to the record that at that time period when they mentioned that they came to find out if there was no permit required, I was the customer service supervisor that controlled the permits also, and there was no exemptions when it comes to accessory structures on the property. but I will get with the building official and see if there's any.
Okay, yeah, I appreciate it. I mean, I understand, like I said, I just want to see the actual provision in the code. And also for the record, Mark just asked me about, well, what would happen, because the shed is actually in the easement, but that's not an issue with the building code, right? So to me, that's not, the issue is getting a permit, and is there an exemption? And I'm not quite sure, standing here today, whether or not there is one. So that's what I'd like to know. So we're going to go ahead and continue it to September 27th, which is the next meeting.
Mas você tem planos para remover?
Okay, thank you.
Nós esperamos até dia 22, porque que ela vai dizer. Tem que remover, tem que chegar.
Se vai ter que, você vai ter que, se não for de acordo com o Código da Flora, vocês vão ter que remover. Ok, então, mas ela vai saber a decisão no dia 22, que vocês vai ter que voltar. A gente vai... A gente vai tirar, né? Remover e tirar. Ok. Okay. They were just asking me if by the 22nd, if it's not up to building code, if they would have the option to remove or tear down the shed. And this was their question were. And if by the time when you learned, when you learn about the building code constructions pertaining to sheds, if it's not up to building code, what their options were. And he was suggesting me that they're just conversing that they wanted to tear down if it's not up to code after their learning.
Okay, yes, I mean, I think, Mr. Ron, you want to respond to that?
Yes, if we can have a contact number, we can get the information tomorrow with the building official when it comes to permit required and because of the sheds in the easement. So they can have an answer tomorrow on that. And the options if they want, if there's options for that.
Okay, wonderful.
But,
all right.
Oh, sorry, but it is an option for them to remove the shed.
Removing the shed from the property will bring them into compliance. That's
Yes.
correct.
Okay.
So that is an option for them.
Oh, wonderful, thank you. Eles estão falando, se vocês remover, a propriedade vai estar praticamente de acordo com o código da cidade, não vai ter problema nenhum. Mas ela quer verificar primeiro. Mas você tem essa opção. Okay, yeah, yes,
Okay.
They're in agreement.
All right, thank you.
No problem. All right. All right. Boa noite, gente. De nada, tá? De nada, boa noite.
Okay, the next case is 23-151. It's a Massey case, 2831 Summerfield Street.
Good afternoon. Okay, my name is Tyler Rousseau. I'm employed by the City of Deltona as a co-compliance officer. This would be Massey case number DEL 23-151. The City of Deltona versus Bridge SFR IV Seed Borrower LLC. The property address is 2831 Summerfield Street. The parcel ID number is 813-043-370-080. The statutory requirements for the notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled that on May 24th, 2023, that the property was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 a day since June 23rd, 2023. As of today, the property has accrued a total fine of $1,550 over 62 days. The city is requesting that the fines continue at $25 per day.
Okay, and it's your testimony that they have not submitted a permit for a permit application?
That's correct.
Okay. Okay, and we have no property owners. Oh, wait, someone just came in, making sure. That's not the property? Okay, all right. I will go ahead and find, I'll admit the case file as Exhibit A. I find the notices were properly given in this case, and I find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance.
Thank you.
Thank you. All right, this is 23-188, also Massey case, 2627 Beale Street. Go ahead.
Okay. My name is Janice Palasic, and I am employed by the City of Deltona as a code compliance officer. This will be Massey case number DEL 23-188A. The City of Deltona versus House Guru, LLC. The property address is 2627 Beale Street. The parcel ID number is 813-074-010-020. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. It was ruled on May 24th, 2023, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 a day since June 23rd, 2023. As of today, the property has accrued a total fine of $1,550 over 62 days. The city is requesting that the fines continue at $25 per day.
Okay, and so it's your testimony that they did not apply for a permit
No,
at this
the shed
time?
is still present on the property.
The shed?
Yes.
Okay. Just give me one moment.
Okay.
Okay. I find that the notices were properly given in this case, and I'm admitting the case file as Exhibit A. I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. Thank you.
Thank you.
Okay. All right. This is case 23-228, 2849 West Huron Drive. Go ahead.
My name is Janice Palasic, and I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 23-228, the City of Deltona versus James Mason. The property address is 2849 West Huron Drive. The parcel ID number is 813-032-900-010. This is a violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain permit for the shed or remove the structure. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation was sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. On May 19, 2023, I addressed this property for a trailer that had a shed on top of it parked in the city right-of-way. I informed the property owner, James Mason, that the shed and trailer needed to be removed from the right-of-way. At this time, I also told him that if the shed was going to be relocated onto his property, a permit would need to be obtained for the shed. Mr. Mason told me that he would go to City Hall and obtain the permit. On June 2, 2023, after noting that the shed was moved from the right-of-way and placed onto the property and that no permit was on file, a notice of violation was posted onto the property. A certified mailing was also sent out to the property owner listed on property appraisers. While on the property, the homeowner again advised me that he would work on getting the permit. On July 13, 2023, after confirming that no permit was still on file, a notice of hearing was posted onto the property. A certified mailing was also sent out to the property owner listed on property appraisers, as well as an affidavit of service was also completed. As of today, August 23, 2023, the shed remains on the property and no permit is on file for the shed. The city would like to request 30 days for the property to come into compliance or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
$50, and you said how many days?
30 days.
Okay. A couple of questions. I will swear you in just a moment. So this was moved out of the right-of-way. Am I looking at, this is a picture from today, am I looking at the street at the bottom of the?
Yes.
Okay. Okay, I'm asking the code enforcement officer at the moment. All right, so that's the street, and then
that's the side of the property.
Okay, and a shed, is a shed permitted in the front yard?
It's in the yard. It's questionable as if it's still, some of it's still in the right-of-way.
Okay, I'm saying per the city's code, is it allowed to stay in that location?
Ma'am, it will not pass the zoning portion of the permit application because of the setbacks on the side street.
Mm-hmm. Okay, I figured as much. All right, I'll go ahead and swear you in, sir. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
All right, can you state your name and address for the record?
James Mason, 2849 West Huron Drive.
Okay,
Deltona.
what would you like to tell me about the case?
It's pretty cut and dry. It's a shed. I don't have a permit. It's not easy to get a permit. It's not. I've been down there several times. They just tell you if you don't have everything they want, they just shoo you away. They don't tell you how to get it. They don't help you with it. You got to have structural drawings for it and the survey, which I finally got the structural drawings. That was the hardest part. I didn't have any idea how to do that. And I finally just got those. So
okay.
All I have to do now is get a survey. And I don't have it secured down, so once I, figure out someone's going to help me, tell me where to put it,
okay,
then I'll put it in the right spot.
Yeah, I'm like Mr. Ron stated, I'm fairly certain that you're not going to be able to keep it in that location.
Yeah, that's fine. I actually wanted it in the backyard, but I didn't want to get too carried away with it until I figured out
Okay.
what was.
All right. Now that you have structural drawings, do you have any concerns with a 30-day time to comply?
I do, because a week after we were supposed to do this last time, I came home and my car and my trailer was gone. And I understand why the trailer was gone, maybe, not really, but no one knows why my car was taken. So that's kind of a problem for me. And it
Your
has a-
car
had a-
was taken,
yeah.
you're saying the car was taken by the city?
Yes. Tag on it, full coverage insurance.
Okay. And how does that relate to the shed?
Financially, it relates to the shed. And it's my car that got taken by the city.
Okay.
You know, so my way to work, it's still sitting down there right now, so I don't know who's going to pay for it to get it out. But
Okay. Again, I don't know. I'm trying to understand how that relates to the time that would be necessary to get a permit for the shed.
A survey is not free, right? Costs money. I don't have very much money. I just started working. That was the whole point. Like, I just started working, and a week before I got my first paycheck, my car's gone. I come home from work.
Okay. Does the
Kind of
city
sets me
have,
back.
go ahead.
What
I
was
thought you were about to say something.
Oh, no, I mean, yes, the city did abate the vehicles due to it being improperly tagged, and yes, a trailer and a car was towed.
Okay. Is there any objection to giving a slightly longer time to comply, or?
Ma'am, I'll leave that up to you, ma'am.
Okay. I think that since you have already obtained the structural drawings, so you don't have a survey?
I don't have a survey, no.
When you purchased the home, it didn't come with a survey?
It has to be a little bit newer, I believe.
It has to be updated?
Yeah, I believe so.
That kind of changed within the last couple of weeks. If you could make arrangements to come to City Hall with what you got, either tomorrow be a good day, I'm here. I can meet you and with the permit department.
Yeah.
And we can go over the details on that. And we'll cover the zoning portion, which the location of that shed, where it could be, so that gives you an idea.
What if I can't make it tomorrow because I work?
Back Monday.
Okay.
How's Monday?
Okay.
All right?
All right.
Okay. I am going to keep it at 30 days. I think that since you have the structural drawings, I think that's a reasonable time. So that's what I'm going to keep it at. So I am going to go ahead and admit the case file as Exhibit A, and I find the notices were properly given in this case. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 22nd, which is 30 days. In the event respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code inspector to verify compliance with this order. So please keep in contact with Mr. Ron and Ms. Pulasic.
Okay. What about my car?
That is not, we're not here to discuss the car. I'm here to rule on.
But are we going to come back to discuss it? There's no court date for that, or no time set for that, and it's just sitting in impound.
That, Mr. Ron, do you have anything to say about that? Okay, yeah, thank you.
Thank you.
All right, the next case is, I'm sorry, did someone say something?
I think that was
Oh, okay. This is case 23-015, a Massey case, 716 Mountain Way Avenue. Oh, Danny needs to present that one? All right, let's,
Just forward it over.
yeah, we can come back to that one. All right, so this is fire case 000006, 2023, 2901 Howland Boulevard.
Good evening, Your Honor.
Good evening.
For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as fire captain / assistant fire marshal. Introduction of this case. This will be case number fire-00006-2023. The City of Deltona versus Cole FD Portfolio 3 LLC. Property address is 2901 Howland Boulevard, Deltona, Florida. Parcel ID is 813-0391-30080. This is a Massey case. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall and on the property at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on May 24th, 2023, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 per day since June 24th, 2023. A reinspection was conducted today on August 23rd, 2023, and it was found that the violation has still not been corrected. As of today, the property has accrued a total fine of $1,525 over 61 days. In closing, the city is requesting that the fines continue at $25 per day until such property owner has notified the city of compliance and compliance is verified by a fire safety inspector.
All right. This case related to Chapter 13.1.6, which requires quarterly inspections, correct?
That's correct. Chapter, I did bring the body of the text with me. Chapter 13.1.6 requires detailed records documenting all systems and equipment testing and maintenance shall be kept by the property owner and shall be made available upon request by the authority holding jurisdiction.
Mm-hmm.
So,
okay, so okay, right. And at the time, I believe the order states that they had provided an annual inspection, but not the required quarterly inspections, correct?
That's correct, ma'am.
All right, and so they have not provided a quarterly inspection as of today?
No, ma'am. And on the picture provided, it's a little bit hard to read. That shows that no further inspections have been conducted on the sprinkler system since our last meeting here.
Okay. So no further inspection since May 24th.
That's correct.
And would they have had to have an inspection between in that period of time?
Yes, ma'am. Every 3 months. So one would have been due some point this month.
Okay. Okay. Just give me one moment. Okay. I find that the notices were properly given in this case, and I'm admitting the case file as Exhibit A. I find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance.
Thank you.
Okay. I have case 23-015, a Massey case, 716 Mountain Way Avenue. Did you want to do the fire ones? What's that? Oh, okay.
Good evening, ma'am.
Good
My name is
evening.
Danny Ron. I'm the Code Compliance Manager.
Yes. Go ahead.
And this is case number DEL 23015. This case was presented back on April the 29th of 2023 of this year as a Massey.
Mm-hmm.
It was found in violations, and we continue to fine. What I'm here this evening is to amend this order.
Mhm.
We did make a mistake, and it should be considered in compliance with no fines. When we presented this case, we did start a fine, and we would like to change that order to show as in compliance with no fines.
Okay, can you explain why?
It looks like when the order was given, it was on the wrong property, and when we did the order, it was for the wrong property. The right correction, the right location was actually in compliance, and we caught it maybe a couple of weeks later, and we would like to correct that.
So the evidence that was presented to me was from another property?
That's correct.
Okay. So you would like me to enter a corrective order to,
Your Massey order for this case.
yeah, my only concern is that once the lien is attached, which it is, right? Because this has been recorded.
That's correct.
Against the property, it's now the city commission's authority to release it. I mean, as you know, typically I would give a recommendation to release it, perhaps to the city commission, but it's not within my authority now that it's actually been recorded to issue a release for the city. So, because that's really was what you're asking me to do.
So let's do that. Yes, we would like your recommendation to correct the order from March the 29th, 2023.
I think probably what I would do is write a recommendation to the city commission and explain the circumstances and say the recommendation is to simply release the lien in its entirety. And I think that would be appropriate.
I worked, ma'am.
Okay. All right, so I will go ahead and do that. I don't think, okay. That's what I'll do. I'll do an order that recommends release in full.
Thank you, ma'am.
Okay.
Appreciate it.
Okay. This is another fire case. This one is 000007-2023 for 1001 Alabaster Way.
For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as a fire captain / assistant fire marshal. This will be case number fire-0007-2023. The City of Deltona versus SNR 24 Sterling Court Owner, LLC. The property address is 1001 Alabaster Way, Deltona, Florida. Parcel ID is 813-078-000030. This is a Massey case. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall and on the property at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I have observed on the day they were taken. It was ruled on May 24th, 2023, that the property owner was given 45 days to comply. The owner has not come into compliance within those 45 days and has been receiving a fine of $200 a day since July 8th, 2023. As of today, the property has accrued a total fine of $9,200 over 46 days. However, I'd like to note that on a re-inspection which occurred yesterday, August 22nd, 2023, it was discovered that one violation pertaining to the 2017 edition of the National Electric Code 70, Article 700.12, subsection F2, requiring the emergency lighting to be installed on the branch circuit of the lighting for the room it serves, has been corrected, as the exit sign is now connected to the branch circuit that serves the lighting for the room. Therefore, in closing, the initial order was to request was for a fine of $200 today. However, due to the fact that one violation has been corrected, the city is requesting that the fines continue at $150 per day until such property owner has notified the city of compliance of the remainder of the violations and compliance is verified by a fire safety inspector.
Okay. And the one that came into compliance was, which one again?
I have the report right here. No, is it 700.12? Yes, Your Honor,
F2.
700.12 F2.
Okay. All right, can you walk me through the others? So we did not find a violation of 7.9.3.1.1.
That's correct. I apologize.
Mm-hmm.
The NFPA, we didn't find a violation NFPA 179311.
Right. Well, but in the order, I stated that the notice of violation cited this as NFPA 1 rather than NFPA 101. So there was no violation on that particular one.
That's correct.
Okay. So then the next one was for chapter 13.1.9.
Yes, ma'am.
Okay. And so, oh wait, I'm sorry. That one came into compliance, right? Prior to the hearing.
That, I believe, the one that came into compliance prior to the hearing was...
Okay, sorry. I'm reading from my order. So it said that the violations for 13.1.9, 13.7.3.1.1.4, and 13.1.6 had already come into compliance prior to the date of my order. So I did not impose any fine based on those or impose any time to comply. They had already come into compliance. So going back to the list here, so we're talking about 13.3.3.2. And, okay, so that was related to the fire sprinkler installed. It has to be inspected, tested, and maintained.
In accordance with NFPA 25, that's correct.
Mm-hmm. And so it had been yellow tagged,
Yes, ma'am.
and you had not received any further
Documentation
that, yes, that it had been inspected and passed inspection.
Yes, and the deficiency that caused the yellow tag had been corrected.
Okay, so you have not received that as of today.
No, ma'am.
All right, and then we have 50, NFPA 1, 50.5.6.15. That one was related to certificates of inspection and cleaning for kitchen exhaust.
That's correct.
Okay, and so also you have not received any documentation on that?
That's correct.
And okay, and then we have 70, no. I'm sorry, I have to go through these one at a time. I apologize. So NEC 70, 700.1.2 or 700.12, that's the one we just discussed, right? That they had come into compliance?
Yes, ma'am.
Okay, and then the last one was 633, Florida statute 633.312 sub 2?
That's correct.
Okay, and okay, that one also was regarding, what, fire hydrants?
Yes, ma'am. The documentation and the inspection, testing, and maintenance reports provided for the privately maintained fire hydrants on the property.
Okay, and they have not provided any documentation of inspection as of today?
No, ma'am.
Okay. All right. Let's see. Give me just one moment to look at the file. Okay, I find that the notices were properly given in this case. Admitting the case file as Exhibit A. I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order, with the exception that going forward it will be $150 per day per the city's request. And it will continue, that $150 will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code inspector. Respondent shall notify the code inspector to verify compliance. Thank you.
Thank you.
Okay. Oh, we have another fire case. You sat down too quickly. What's that? Okay, and one more after that. Two more, okay. This is 10-2023, also at 1001 Alabaster Way. Oh, this one is not a Massey, correct?
That's correct. This is not a Massey.
Okay.
one, all right. For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as a fire captain / assistant fire marshal. This will be case number Fire 010-2023, the City of Deltona versus SNR 24, Sterling Court Owner, LLC. The property address is 1001 Alabaster Way, Deltona, Florida. Parcel ID is 813-078-000030. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1 Fire Code and NFPA 101 Life Safety Code. This particular case is a violation of Section 7.9.3.1.1 of NFPA 101, which requires functional testing of the emergency lighting to be conducted monthly and written documentation of the testing of the emergency lighting system to be provided to the authority holding jurisdiction upon request. Corrective action for said violations is to provide current written testing logs of the testing for all emergency lighting systems in the building. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On September 14th, 2022, Fire Safety Inspector Ajory Bailey conducted a fire inspection at this above location. Among several other violations, which have since been corrected or brought before this magistrate under case number Fire-00007-2023, he observed the above-mentioned violation, in which no emergency lighting testing logs were on site to be able to be reviewed. He informed the property manager and maintenance of this violation. Due to the extensive list of violations found on the initial inspection, the property was given until January 12, 2023 to correct said violation. Upon subsequent reinspection on January 12, 2023, said violation was not corrected. Subsequent reinspections have occurred on February 27th, April 1st, March 13th, May 8th, May 24th, and July 18th, all of the year 2023, and this violation still has not been corrected. Reinspection was conducted yesterday on August 22nd, 2023, and the violation has not been corrected. As of today, August 23rd, 2023, the violation is still outstanding as we have not been provided with a written log of the testing of the emergency lighting system. In closing, the city would like to request 30 days for the property to come into compliance or a fine of $25 per day until such time that the property owner has notified the city of compliance and a fire safety inspector has verified the compliance.
Okay. You don't have photos or anything of this? I mean, because this is just an issue of...
I was about to say, unfortunately, I can't provide photos as much as I would like to, just simply because no logs exist.
Yeah.
The only thing I could provide would be photos of every emergency light inside the building.
Okay. But your testimony is there are emergency lights in the building?
Yes.
Okay.
Yes, ma'am.
All right. I find that the notice was properly given in this case. I'm admitting the case file is Exhibit A. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 22nd, which is 30 days. In the event respondent does not comply by this date, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance.
Thank you. I'll go grab my next one.
All right, I have case 11-2023 now, which is 2001 Saxon Boulevard.
For For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as a fire captain / assistant fire marshal. This will be case number fire 011-2023, the City of Deltona versus Racetrack Petroleum, Inc. The property address is 2001 Saxon Boulevard, Deltona, Florida. Parcel ID is 813-003-000-110. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1 Fire Code and NFPA 101 Life Safety Code. This particular case is a violation of Section 63.9.2.1 of NFPA 1, which requires that, other than for vehicles equipped for and using compressed gas as a fuel for propelling the vehicle, an operational permit shall be required for liquid carbon dioxide systems in excess of 100 pounds or 45.4 kilograms, and Section 11.1.8 of NFPA 1, which requires all panel board and switchboards, pole boxes, junction box, switches, receptacles, and conduit bodies be provided with covers compatible with the box or conduit body construction and suitable for the conditions of use. Corrective action for said violations is to obtain an operational use permit for the usage and dispensing of liquid carbon dioxide in a system that contains greater than 100 pounds through the City of Deltona Building Department, and to provide an approved cover plate for the opening inside of the electrical panel. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On March 30th, 2023, Fire Safety Inspector Jory Bailey conducted a fire inspection at this location. Among several other violations which have since been corrected, he observed a 550-pound liquid carbon dioxide tank being utilized for the dispensing of fountain beverages with no operational permit on file for the usage of this system. He also observed an opening inside of the electrical panel / breaker box on the rear of the building, which was not equipped with an approved cover. Store management was informed of these violations. Fire Safety Inspector Bailey conducted follow-up inspections on May 3rd, June 1st, July 5th, and August 3rd, all of the year 2023. On the August 3rd, 2023 re-inspection, myself and Fire Safety Inspector Bailey observed the opening inside of the electrical panel had a cover placed on it. However, the cover was that for a wall-mounted electrical receptacle and was glued in place inside of the electrical panel. This is not an approved method of providing a cover for the inside of this electrical panel. We informed the store manager of this, who advised she would pass it on to her maintenance staff. On August 17th, 2023, an operational use permit for the usage of the liquid carbon dioxide system was applied for. However, the system still has not passed the required inspection for the issuance of this permit. Therefore, there is still no permit issued for the usage of this system. A re-inspection was conducted today, August 23rd, 2023, and it was found that the opening inside of the electrical panel is still covered with the glued-in-place cover. There's also no permit issued for the liquid carbon dioxide system. In closing, the city would like to request 30 days for the property to come into compliance, or a fine of $50 per day until such time that the property owner has notified the city of compliance and a fire safety inspector has verified compliance.
Okay, thank you. So on 63.9.2.1, you said it was well over the number of pounds, correct?
That's correct. The threshold for needing a permit is 100 pounds. The specific tank we mixed or observed is a Carbomizer 550. The 550 stands for 550 pounds.
Okay. And this is at a restaurant?
This is the back of a racetrack, a large gas station.
Oh. Okay. And so you said they applied for the permit when?
August 17th, 2023.
Okay. And so you would anticipate 30 days would be sufficient for review of that permit and...
Yes, ma'am. Although I don't see the property owner or a property owner's representative here, we've been in contact through email up to today. I let them know exactly what they needed to pass the inspection for the system. They need to have a detection device in case there's a leak, and proper signage on the rear of the building for the emergency response crews that may respond there in the event of a leak. And they are working on it. So 30 days, I think, would be enough for compliance.
Okay. And then, just give me one moment. And then for the electrical panel, they just need to have you talked to them about what would be an approved cover?
Yes, ma'am. I actually use an example. So all of those squares, except for the one the most to the right, all of those square components you see are covers for blanks where you could add another circuit onto that panel board. As we see right here on the right, that is actually a blank cover for a wall receptacle that someone glued in place. When I met them out on site, I said simply we need to just call, well, not we, but the property management needs to call the company that makes this switchboard and just request another blank plate. Personal experience, those blank plates are actually usually pretty easily obtainable at any electrical supply store.
Okay. But the other, it's just that one that I'm seeing that has the white glue, apparently.
That's correct, Your Honor. And
The
there's
other
white
ones
glue.
are-
There's white glue on the other side too. They tried to use a black marker, I think, to cover it up.
Okay, but the others are appropriate covers.
Yes, ma'am.
Okay, all right, thank you. All right, and I'm going to separate the fine for the two, so it would be, you would have no objection for it to be 25 and 25?
No, not at all.
Okay, all right. I find that the notices are properly given in this case, and I'm admitting the case file as Exhibit A. I find respondent in this case in violation of the city code as charged, and that respondent correct the violations before 4:00 p.m. on September 22nd, which is 30 days. And in the event the respondent does not comply by the state, a fine in the amount of $25 each will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. Thank you. Okay. 23-237, 1479 East Hancock Drive. You can go ahead.
This will be case number DEL 23237, the City of Deltona versus James Michael Sr. and Marie Frazier. The property address is 1479 East Hancock Drive, Deltona, Florida, 32725. The parcel ID number is 813-030-190-050. This is a violation of the City of Deltona Ordinance, Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent, who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system the installation of which is regulated by this code, or to cause any such work to be done, shall first make application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit for the door or garage enclosure area. Applications must be submitted to the City of Deltona, 2345 Providence Boulevard, Deltona. The structure must meet all requirements of city ordinance and be approved on final inspection. Contact our office when the permit has been obtained. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On May 29th, 2023, I was on a proactive review of the area. I noticed a home undergoing some construction on site. The garage door area of the home had a door with plywood siding in place. A review of the history on the property showed a garage door intact at one time. I approached the homeowner on this day, discussed the door on the front of the garage, and I indicated that the removal or placement of the new door would require a permit. The homeowner said he would obtain a permit as soon as possible. I conducted an inspection on July 4th of 2023 and noticed the added siding to the door area. I also noted the closed door on the side of the home with plywood, which would require a permit as well. I checked case records for any permit applications in the following days. No submittal for a permit. I returned to the property on July 17th and posted the notice of violation. I was able to talk to the female homeowner on the violation of no permit and advise of the possible need for another permit for the interior work inside the garage area. I could see some framing through the window of the garage. She shared with me that her husband had some things that were going on that was delaying the attempt to get the application in for the permit. No submittal of application for a permit or contact with the building office have been noted since the July 17th date. As of today, the homeowner did come down to City Hall to attempt to begin the permitting process. So they have made an attempt in contact with the building and the code office.
That was today?
That was this morning here, about 9, 10 o'clock. And that the city would like to request 9 months for the property to come into compliance, or a fine of $25 per day to be imposed until such time that the property owner has notified the city of compliance.
9 months and $25?
Yes.
Why such a long period of time?
They have to, with the doors and possibly anything that's going on inside, they have to get the proper material documents to show, to turn in with that, and the potential drawings, certified drawings, engineered drawings with the property. And basically, I think they had they had some personal things going on too. They shared that was delaying the attempt to get there.
Okay.
Give me a second, ma'am.
Okay.
We're going to go ahead, we'd like to revise that to 90 days and $25.
90 days?
90 days, yes.
Okay. All right. Mr. Ron, so you believe that 90 days would be sufficient to obtain a permit
That is
for
correct.
this kind of work?
They were made aware, when the case started. They show up today to request time. We'll work 90 days should be sufficient. We need to get them rolling on this. 9 months is too long to obtain a permit on this.
Okay. I mean, out of curiosity, were the homeowners told you were going to request 9 months?
When they came in, I was in the office, but my supervisor, along with the building department, spoke with the resident, and they had worked out what they thought was 9 months, to get the sufficient information to get the application in. I think possible survey may have been needed, along with all the components, the door, the siding, and they would have to provide all that, material data sheets that would show what materials they were using on the door, if it was met code and everything like that.
Okay, so with the building official, that was kind of the schedule that was discussed?
I don't think it was
if I can interrupt.
Yes.
Did. I was the one that spoke to the permitting department when the resident came in.
Okay.
She wasn't able to give me a definitive time frame because we have no idea the extent of work that they've done on the inside, just what we can see on the outside. They're enclosing it and making some sort of room in there. So there's a lot of engineer drawings, some product approval information that needs to be submitted, and probably even a survey at some point from what I understood. So we said, well, 6 months or 9 months, and she's, I don't know. So we can be flexible and do the 3 months and hope that they can get everything done.
Well, the only thing that is charged at this point, though, I mean, based on the notice of violation, is to get a permit for so when you say the door, it says door or garage area.
Correct.
Are you really talking about the entire interior?
Well, I first noticed the door when I came onto the property. As I came in and spoke with the owner, through the window, I could see there was framing done inside here. There's some framing, and I mentioned too, when I handed the notice, I said, is there any work that is going on inside of the garage, such as you creating another room, that you would have to basically get a permit for that, and that would may require contacting the health department, because if it's made any type of living quarters, it have to be notified by the health department to what added living space to the house.
All right, so when you put in the notice of violation that it's the garage enclosure area, that was the interior of what used to be the garage.
Right, because they technically they weren't truly admitting to me that they were done something inside, but through my observation, I would say that they are enclosing it, because in one of the other pictures, there's a shower pan outside on the front by the garage, so it's suggesting that there may be something more going on with inside the garage.
Okay. I mean, since 6 months was discussed with them, is the city opposed to 6 months?
I'm okay with 6 months, ma'am.
Yeah, I mean, since that was discussed with them, that's what I'm inclined to do.
I did just say make the recommendation. I advise them that we'll make the recommendation, but I can't guarantee that that's what they will get. And she understood with that. And I, advised her to come tonight, but there was some family issues, so.
Okay, all right. Then I guess I'll do the 90 days then. All right, so I find that the notices were properly given in this case, and the omitting the case file as Exhibit A. I find that respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on, that would be November 21st, which is 90 days. In the event respondent does not comply by the state, fine in the amount of, you recommended $25?
Yes.
$25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order.
Right. Thank you very much.
Okay, this is 23-242, 3775 Trade Street.
Afternoon. My name is Tyler Russo. I am employed by the City of Deltona as a co-compliance officer. This will be case number DEL 23-242. The City of Deltona versus Rodriguez Marisol, Risner Carl Joseph Jr., and Risner Yvette. The property address is 3775 Trade Street. The parcel ID number is 813-062-370-030. This is a violation of City of Deltona Ordinance Section 18-5, adopting the latest edition of the International Property Maintenance Code, Section 304.6, which states that all exterior walls shall be free from holes, breaks, and loose or rotting materials, and maintained weatherproof and properly surface coated where required to prevent deterioration. Corrective action for said violation is to repair the exterior walls. The statutory requirements for the notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This case was initiated on April 14, 2023 for the siding missing on the second story of the dwelling. During my numerous re-inspections at the property, I haven't had any contact from the homeowners. Today, around 12 p.m., I returned a phone call from Ms. Rodriguez after she left me a voicemail, who was the property owner. She informed me that the siding was missing due to Hurricane Ian, and she was able to put a claim in shortly after the hurricane, but the insurance company went bankrupt shortly after. As of today, the violation still remains. The city would like to request 60 days for the property to come into compliance or a fine of $25 to be imposed until such time that the property owner has notified the city of compliance.
Okay, so the owner did not give, when you spoke to her, did not provide any time frame in which they intended to?
She did not give me any time frame, no.
Okay. And so I'm just making, what am I looking at on the siding? Is it the siding that's missing?
Yes, so there's paneling that was on the side of the house that fell off, I guess, due to the hurricane.
Okay.
I know there's a specific name for the material. I don't know construction that well, so I don't know about the what it's called, but the siding's supposed to be covering that material.
Right. It's some kind of a
like a paneling.
Lining or barrier or something. Yeah. Okay. I find that the notices were properly given in this case, and I'm admitting the case file as Exhibit A. I'm going to find the respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on October 22nd, which is 60 days. In the event respondent does not comply by the state, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order.
Thank you.
Thank you. Okay, this is case 23-245, 661 Piedmont Drive. Go ahead.
My name is Lindsay Longstreet. I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 23-245, the City of Deltona versus IMAS Deltona LLC. The property address is 661 Piedmont Drive, Deltona, Florida, 32725. The parcel ID is 813-003260110. This is a violation of City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or to cause any such work to be done, shall first make an application to the building official and obtain the required permit. Corrective action for said violation is to obtain a permit or remove the structure. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with property appraiser's records. In addition, both notices were posted on the property and City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On May 4th, 2023, I arrived at the property as they had replaced the fence but did not obtain the required permit. I spoke with a female tenant who advised that the landlord was made aware a permit was needed prior to the fence being replaced. On March 17th, I posted the property with a notice of violation since no permit was obtained yet, with a compliance date of May 27th, 2023. On May 24th, 2023, I received a phone call from the property manager looking for more information about the permit. I explained one was needed due to the fence being replaced. Multiple conversations were had with the management company after my initial interaction. I advised many times by the property management company they would get the required permit. On August 4th, 2023, I posted property with a notice of hearing as no permit was obtained. And as of today, August 23rd, 2023, the property still is in violation with no permit for the fence. And in closing, the city would like to request 30 days for the property to come into compliance or a fine of $25 per day to be imposed until such time that the property owner has notified the city of compliance.
Okay, and they haven't even applied yet?
No, ma'am.
Okay, and just from the pictures, you know that there's a new fence just from the color, or did you actually see it being?
I've had a previous case where they had, the fence was in disrepair. They were notified upon that case that in order to replace the entire fence that they were going to need a permit for it.
Okay, so they fixed it,
but didn't get the required permit. Yes, ma'am.
Okay, thank you.
You're welcome.
All right, I find that the notices were properly given in this case and admitting the case file as Exhibit A. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 22nd, which is 30 days. And in the event respondent does not comply by the state, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order.
Thank you.
Thank you. All right, we have the fire case 12-2023, 407 Deltona Boulevard.
For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as a fire captain / assistant fire marshal. This will be case Fire 012-2023, the City of Deltona versus Racetrack Petroleum, Inc. The property address is 407 Deltona Boulevard, Deltona, Florida, 32725. Parcel ID is 900-111-000010. This is a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1 Fire Code and NFPA 101 Life Safety Code. This particular case is a violation of Section 63.9.2.1 of NFPA 1, which requires that, other than for vehicles equipped for and using compressed gas as a fuel for propelling the vehicle, an operational permit shall be required for liquid carbon dioxide systems in excess of 100 pounds or 45.4 kilograms. Corrective action for said violations is to obtain an operational use permit for the usage and dispensing of liquid carbon dioxide in a system that contains greater than 100 pounds through the City of Deltona Building Department. The statutory requirements for notification for this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. January 5th, 2023, Fire Safety Inspector Joy Bailey conducted a fire inspection at this location. Among several other violations which have since been corrected, he observed a 550-pound liquid carbon dioxide tank being utilized for the dispensing of fountain beverages with no permit on file for the utilization of this system. Store management was informed of the requirement to obtain an operational use permit for the system. Inspector Bailey conducted follow-up inspections on February 17th, March 21st, and August 9th, all in the year 2023, with no permit yet issued for the liquid carbon dioxide system. On August 17th, 2023, an operational permit for the usage of the liquid carbon dioxide system was applied for. However, the system has not passed the required inspection for the issuance of the permit. Therefore, as of August 23rd, 2023, there is still no operational use permit issued for the usage of this system. In closing, the city would like to request 30 days for the property to come into compliance or a fine of $25 per day until such time that the property owner has notified the city of compliance and that compliance has been verified by a fire safety inspector.
Okay, so the chapter 11.1.8 you said came into compliance?
No, that wasn't on this case, Your Honor.
Oh, wait. Okay, it's in my agenda, but that was a mistake in the agenda.
It must have been. Yes, ma'am.
Okay. I mean, it's on your notice of violation. But maybe that was a mistake as well.
It looks like it was mistakenly put on there.
Okay. All right. Well, that's
Yes.
fine. All right.
Yeah, there is no violation of NFPA 1, Chapter 11.1.8.
Okay. All right. So, and do you have pictures for this one as well?
I do not.
Of the tank? No.
I actually brought one with me. Let me make sure it's here. No, it didn't attach to my report.
Okay. But have you inspected it?
Yes, ma'am.
Okay.
I was there yesterday. It's
were there.
another 550-pound carbomizer,
Okay.
cryogenic cylinder for the liquid CO2.
Okay. And, all right, so they have applied, but they haven't gotten it yet, and you believe 30 days to be sufficient to get?
Yes, ma'am. I've been in almost continuous contact with the property owner's representative, working through the process to get the permit. They just need some signage and a CO2 detection system installed in the area where the cylinder is contained.
Okay. Thank you. All right, I find that the notices were properly given in this case, and I'm admitting the case file as Exhibit A. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 22nd, which is 30 days. And in the event respondent does not comply by this date, a fine in the amount of $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code inspector to verify compliance with this order. Thank you. Okay. Any further business? Okay, then we'll go ahead and adjourn. Thank you.